Kessler here. I'm on the faculty of the law school. I'm so happy to be here. And I'm here to moderate our second panel, which is on carceral logics in civil institutions and legal systems. So the purpose of this panel is to examine the ways that the punitive logic of the criminal justice system has seeped into civil institutions, such as in the educational system, the healthcare system, the child welfare system, as well as into civil law, and to examine how that criminalization in civil contexts it has had devastating effects on marginalized people and communities, and in particular on women. And so we have three distinguished speakers today who are experts in this topic. I'm very excited to have a really distinguished panel. The first speaker is here with me today is Dr. Geniece Crawford-Mondé, is an associate professor of sociology at Furman University in Greenville, South Carolina. Professor Mondé earned her PhD in sociology from Harvard University, and today she's going to discuss her book. I'll give her the honor of sharing, well, I'll do it here. This is her amazing book. This is Our Freedom, Motherhood in the Shadow of the American Prison System, published with the University of California Press, which examines how formerly incarcerated mothers navigate the complex journey of rebuilding their lives while experiencing surveillance and mistreatment in the civil context after their imprisonment. Our second speaker, I'll just say that two of the speakers unfortunately couldn't be here in person. So the second speaker we're delighted to have today is Professor Priscilla Ocen of Loyola Law School. Professor Ocen is the co-author, along with Kimberly Crenshaw and Jyoti Nanda, of a very influential policy report, Black Girls Matter, Pushed Out, Overpoliced, and Unprotected. Most recently, she served as a special assistant to the Attorney General of California, advising on California's AG on criminal justice reform. And she's going to speak today, echoing some of the themes of the first panel, on the ways that post-Dobbs law enforcement is employing its vast capabilities to surveil, detect, and arrest and punish people who seek abortions. And then finally, we have Professor Wendy Bach, who's a professor of law at the University of Tennessee in Knoxville. Professor Bach, her presentation is recorded. So she's also going to be virtual, so to speak, but she's dedicated her career to representing children and families in poor communities. In her previous work before moving into academia, she was a director of a homeless prevention project and a legal aid attorney in New York. And today she's going to discuss her book, Prosecuting Poverty, Criminalizing Care, which is a study of the prosecutions of poor women in Tennessee for the crime of fetal assault and the spiraling impacts that those prosecutions have on their lives. So without more, let's start. Welcome, Professor Mondé. So happy to have you here.
Thank you, Laura, for inviting me. I am so excited to be with you all here this morning to discuss what I think is a really critical issue facing women and incarcerated people in our society. I bring you greetings from the state of South Carolina, and I hope that as I share this information, you will carry it with you and think critically about this going forward. Today, I'd like to center my comments on the ways that formerly incarcerated mothers experience social exclusion and how that carceral experience extends both in formal and in informal ways beyond the time that they are in correctional institutions. Throughout my presentation, I used the framing carceral logics of benevolence to underscore how the rhetoric of care so pervasive throughout our various systems, both explicitly and implicitly belies the fact that institutions often perpetuate and create new harms for these vulnerable populations. So I am a sociologist, and so my framing of this comes from that perspective. I interviewed approximately 70 formerly incarcerated women. Some were in residential transitional organizations, some were in non-residential transitional organizations, but all of them were trying to regain custody of their children. They were trying to rebuild their lives. They were trying to, in many ways, move forward. And through those interviews, there were three broad themes, one of which will be the focus of my talk this morning. First, one of the things that I think is so critical for us to do is to challenge this false trichotomy between life before prison, life during prison, and life after prison. For many of the people that I spoke to, and for many incarcerated and formerly incarcerated people in general, their life experiences fall under this broad umbrella of interconnectedness with carceral institutions. So distinguishing those periods oftentimes really doesn't give a clear and accurate representation of just how intertwined many of those experiences are, even before they stood before a judge, many times even after they are released from their respective jails and prison institutions. Secondly, my hope is to show how women navigate this very complex moral status that they face. The women that I spoke to are not acted upon. They do not lack agency. Even though their voices are often ignored, they are not voiceless. And I was very clear in my research and in writing my book that I was not in any way giving voice to these women. These women have voices. Although many times, unfortunately, they are silenced. And thirdly, my goal is to explore how women understand their marginalized identity, and that identity is oftentimes extended after they leave correctional institutions, and how they resist those spaces. Some of the influences in my work have been Black feminist scholars like Bell Hooks, who speaks about the status of marginalization being a space of resistance. And I think the experiences of the women that I interviewed illustrate that. So when I talk about carceral logics of benevolence, I want to be clear. I do not use benevolence in kind of a general way. I use it in a very particular way. When returning citizens are released from prison, they are told to seek support. Oftentimes, this is not, a benign request. This is a requirement. This is a condition of their parole. This is a condition of their probation. And more generally, this is a condition of them being quote unquote successful. However, when women encounter these institutions, transitional organizations, hospitals, social services, their carceral identity is first the means by which they are seen, the lens by which they are seen by various actors within these institutions. And so the benevolence they seek, right, the support they seek is often denied because of who they are and because of their past. And I think that these women can articulate those experiences far better than I can. And so I will be reading to you a few cases in the time permitted that I think really underscore just what it means for them to encounter these institutions. So this is April. When I met April, she was 25 years old. She was the mother of 2 children. April was white, and I do speak more in depth about race in my book. But for her, while race may not have been the initial barrier, her carceral experience absolutely was. And so this is April. So they have a birthing center at Cambridge Hospital. This is Cambridge Hospital in Cambridge, Massachusetts. And I said, that's where I want to give birth. And she, referring to the nurse, was like, oh, only normal people can do that. And I was like, what? Well, I gave birth to my daughter at home in a bathtub and all by myself, no midwife. I know how to do this. She, referring to the nurse, was like, no, you're homeless, you're a criminal, you can't. We only let normal people give birth in that place. You have to give birth in the hospital because we don't know what you're going to do. And I was like, I was so offended. And then I was like, fine, I'll give birth in the hospital, but I do want a natural birth. And she was like, no, we don't give natural births in hospitals. You have to have an IV put in you instantly, no matter what. And I'm horrified of needles. I'm not giving birth. It's not going to happen. The baby will stay in me. It won't come out as long as there's a needle in my arm. It won't happen until you take that needle out. I just can't stand it. So Mount Auburn Hospital, I just went there and they were totally fine. They didn't even ask any questions. Cambridge Hospital said that I'm not normal. And they, referring to Mount Auburn Hospital, were like, oh yeah, you can give birth here. So April's premise for requesting the type of birthing experience that she wanted wasn't denied because of pre-existing health conditions, which would be reasonable if that would put her or her unborn child at risk, but because of her experience. And so her encounter after she leaves jail with this nurse, there's no indication that this was broad hospital policy, but this was the nurse's response to her. Her request was denied because of that experience, and there's no indication that it was for any other reason. We also see these negative experiences with social services, and this is something that scholars like Dorothy Roberts have spoken about time and time again, that child welfare systems are often seeking the welfare of children in name only because they often exact a penalty on marginalized families. So Isabel, an African-American mother, I believe she was 28, a mother of one, pardon me, speaks about a drug test and the results of that drug test and the consequences. And so this is Isabel. I went and did a urine the next day. I paid for the urine. I pay for one every week. And then she, referring to her caseworker, was like, was late, pardon me. She didn't come. I called, there was no answer. Finally, at 5 o'clock, I reached her and she said, oh, something came up. I'll be there in half an hour. She came with another person, and then I knew something was going on. She came in and said, I'm here to tell you that your urine on Friday was positive for cocaine. I'm going to file a petition of protection. I have no idea what you're talking about. I've never heard anything about that before. I've never lost my children. I didn't understand what she was talking about. There's no way my urine is dirty. Something is wrong. She was like, well, go in front of a judge and you can talk to the judge about it on Friday, because I had a hearing in 2 days. So I was like, where's my daughter going to be for the next 3 days? I felt like I was in a nightmare. Then they came and they took her. I felt like I was in a movie. You know what I mean? Putting her in a car and she screamed and screamed. It was horrible. I knew something was wrong, so I went to have the sample retested. I called everybody. I knew it was wrong. I couldn't get the results, but finally I called the next day and a worker finally called me back and she said, oh, we read the urine wrong. It wasn't cocaine. It was benzoate. I said, are you kidding me? Am I going to get my kids back? And she said, no, we were considering doing it anyways because of your relapse history. I know you did something. This is the caseworker speaking to her. I know you did something wrong because you're covering up what you did wrong. There's nothing I can do. It happened, so I just have to do what I got to do to get them, referring to her children, back. Isabel's account underscores how what might be considered what I call the 4R mantra of post-incarceration: reentry, reintegration, rehabilitation, and redemption are not without barriers that these women face over and over again. The famed carceral geographer Ruth Gilmore frames the myth of formerly incarcerated people as being able to live lives outside of the criminal dragnet. And we certainly see this with Isabel, who, even though she complied with the expectations of her probation, even though there was an error on the part of her caseworker, she lost custody, at least temporarily, of her child. Then we have Chloe. She's a 28-year-old mother, white mother of 3 children. And she speaks to the challenges that women face who are in these transitional organizations. We can call them halfway homes, if you will, the step before being fully independent after they leave correctional institutions. So I asked her about her experience in this program. We're sitting in one of the offices, and I asked her how she felt things were going. This program, Chloe says, has taught me you are always stuck in the system wherever you go. And then I asked her, what do you mean by that? And she says, Mother's Love, this is a fictitious name of one of the organizations. Mother's Love, can I talk bad about them? Is it going to get back to them? So this is her, she's just double checking, even though there's a promise of confidentiality. And so I told her, no, we're confidential. And so then Chloe says, okay, Mother's Love makes you feel like you are nothing without them. You can't do anything without them. They are your crutch. Make you try to get beyond the system beyond here is difficult. You can't even get a real job, because if you get a real job, then you will have to pay rent and groceries and this and that and everything else. But if you are at our women's working program, you can get assistance and collect a stipend and collect your welfare benefits and be directed, and you can be clean. And that's great. And all that talk about training, it's a joke. So for Chloe, who initially, and this is true for all of the women I spoke to, who are initially very optimistic about their experiences in these programs, later realized that there was, again, this experience of carceral oversight, being monitored, being surveilled, being told what to do, being told what not to do. They expected this from courts. They expected this from their probation officers. They expected this from their parole officers. They didn't expect it in this context. And so for them, it felt almost like a betrayal. That was kind of the framing. And so again, the sense that there were people who were going to look out for them, that myth in many ways was ruptured once they were in these organizations and ultimately began to leave. And so this is Crystal. This is the final case that I will discuss. Crystal is an African-American mother of 1, and she reiterates in some ways Chloe's experience. They're both, at the time I spoke to them, at the same organization. So here's Crystal. They're money hungry. Okay, for example, when it's time to go down to your welfare appointments, there was an incident when I got custody of my daughter, and she wasn't added into my case right away. And it took about 4 or 5 months, and they'd call me down to the office, meaning the organization. They'd call me. So then I'd need to go down to the welfare office, or I was going to get kicked out of the program. And it was like only $25 they'd pay for the kid. So it's really money hungry. They're all about publicity. The more people you get here, the more welfare pays your rent or whatever, how many kids you have in your budget. So it wasn't really like they give you a place to stay, but you have rules and stuff like that. I mean, they're money hungry. She says money hungry about 3 times. And so what does Crystal's experience, and more broadly, the other experiences of the women that I speak to, reveal? They underscore the fact that this language of care is really not accurate. In some ways, I would argue it's even dangerous because, again, it belies the fact that many of these institutions are beholden to these correctional institutions. Some of you may have heard of the prison industrial complex. Well, many of these organizations, like this transitional organization, may fall under what might be called the nonprofit industrial complex. Women are referred to those organizations. They may receive state subsidies for the services they provide, but in turn, they have rules and regulations that they must enforce, and that in turn expands the experience of carceral oversight to these women. Carceral logics in benevolent placements essentially sets up returning citizens like mothers and daughters and sisters to fail over and over again. And when they ask, where can they go? They are redirected back to the very institutions that have closed the doors on them before. And if they can't find success there, whatever success means in that context, they are told that they have no one to blame but themselves. And so I will end my comments there, and I look forward to any inquiries or thoughts from the audience. Thank you.
Okay, so next, Professor Ocen will present.
So first of all, thank you all so much for the invitation to be here. And I especially want to thank the organizers of today's symposium for their flexibility in ensuring that I could still participate remotely. I really appreciated all of the understanding and care that everyone showed in doing so. So I'm going to talk a little bit about the criminalization of hospitals, the criminalization of care, particularly reproductive care, in the context of abortion criminalization that's taken place after Dobbs. So in the past, my work is focused on criminalization and policing of women, girls, and femmes of color. I also explore the racial and gender dynamics of policing and the ways that policing impacts the reproductive autonomy of vulnerable people and communities. I've explored the ways that law enforcement has surveilled and policed the bodies of pregnant people while they're incarcerated by shackling people during labor and delivery, or by restricting the kind of reproductive care or the type of, even indeed the type of food and water that they might receive while incarcerated, or even how they might deliver their child. I've also written about the ways in which poor, particularly Black and Latinx people have been criminalized for their behavior during pregnancy, which Professor Bach will talk about in more detail during her presentation as well. But in the wake of Dobbs versus Jackson's Women's Health Organization, how states enforce full or partial abortion bans has taken on increased urgency, with many unsettled questions that pro-choice scholars and advocates have raised with respect to liberty guarantees in state constitutions. In response to Dobbs, they've pushed for expanded First Amendment protections for access to abortion drugs and legal support for people seeking abortions and their right to interstate travel. There's been less engagement, however, with how and to what extent police will investigate and prosecute people who violate abortion laws in states where there are restrictive laws in place. How will police receive reports of abortions? Will it come from medical professionals or community members? Will enforcement focus on women or doctors? Will women be coerced into testifying against doctors who may perform abortions in violation of abortion laws, or against nonprofits who may aid them in obtaining abortion or abortion pills? And the broader question, which is what's the best way to fight these laws and expand reproductive justice for all? So in my time with you all, I want to explore some of these questions by analyzing pre-Roe policing, as well as a few post-Dobbs examples. Based on the survey of historical and contemporary cases, I make 3 points, 2 of which are descriptive, and 1 of which is normative. First, as a descriptive matter, I want to make what I think is a pretty clear and basic point, which is that police are central to the ability of the state to restrict not only abortion, but reproductive autonomy more generally. It's the police who investigate and potentially arrest abortion providers. It's the police who have sought the records of people who obtain medication for abortions. And it's the police who threaten to imprison women who are accused of doing something to harm fetal life while pregnant. Second, that the police are enmeshed in healing institutional spaces such as hospitals and clinics in the ways that my co-panelists just described, and in the ways that Professor Bach will describe during her time. Policing exists, as we know, beyond the formal bounds of police departments, extending into places like schools and hospitals and so-called helping professions like social work. And then the last point is that the existing statutory and constitutional limits on police power are insufficient to protect the interests of pregnant people. And as a result, advocates must go beyond pushing for the restoration of the pre-Dobbs legal regime. And instead, I make the normative argument that given the critical role that police play in restricting reproductive choice, scholars and advocates should shift some of their efforts away from the courts and the legislature and to police. Scholars should take seriously the question of abolition to secure and protect reproductive justice. They should ally themselves with abolitionist movements to not only expand access by limiting police power and in so-called caring agencies, but it will also expand the broader pro-choice coalition so that wins can be protected over time. So now I want to talk about, very quickly, 3 stories of policing of abortion, one in the pre-Roe era, one in the era of Roe, and one in the post-Dobbs era. So one of the things that I think is really interesting is the way that law enforcement organized itself to enforce abortion restrictions, even in places like California. In places like California and Los Angeles, the Los Angeles Police Department created what was known as the abortion detail. They were charged with enforcing California's ban on abortion, which had exceptions for things like the life of the mother. According to reports by the LA Times on this unit, quote, the abortion squad fielded calls from hospitals, which were obliged to report any sign of criminal abortion. As women grievously harmed in crudely done procedures lay on their deathbeds, officers tried to get the names of the person who performed the abortion for their, quote, dying declarations, unquote. So I want to tell the story of a woman who was affected by this abortion detail, a young woman who was 19 years old in 1966, and she found herself unexpectedly pregnant with a pregnancy that she didn't want. She was young and wanted to go to school. She had dreams for her life that didn't involve her being a mother at that time. She sought an abortion that was not therapeutic, which was illegal under California law. She went to go see a doctor that performed illegal abortions. She had the abortion conducted, and the doctor admonished her when she left that if she experienced any bleeding or any signs of an infection, that she should go to a hospital right away. But instead of telling the hospital professionals what in fact had occurred, to tell them that she had experienced a miscarriage and needed antibiotics. Sure enough, the day after the abortion, she experienced symptoms of infection. She went to the hospital and immediately confessed to having an abortion because she didn't want there to be any barriers between her and her caregiver. She wanted them to be able to help her as much as possible. But instead of treating her with care and compassion, the hospital staff at the facility that she went to immediately alerted police, who came in and began to question her, not as a patient in need of care, but as a criminal suspect. Initially, she tried to protect the doctor to ensure that he could continue to help other women, but the police threatened to investigate her sex life, her sexual partners, talk to her family, co-workers about her sex life and how she might have ended up pregnant, and the fact that she had obtained an abortion. Based on these threats, she provided information to the police that ultimately led to the arrest of the doctor who performed the abortion, who was later charged with a violation of California's criminal abortion law and conspiracy to commit an abortion. He later pled guilty to a misdemeanor. So that's the first case. The second case is a case that took place during the context of legal protections afforded to abortion under Roe versus Wade and Casey. So although Roe was decided in 1973 and granted people the right to abortion under the US Constitution, pregnant people continued to experience criminalization nevertheless, just like the previous example in the pre-Roe era. Indeed, a report from Pregnancy Justice found that since Roe, thousands of women have been prosecuted for things like using drugs during pregnancy or otherwise harming fetal life during pregnancy. Beibei Shui was one of them. In 2010, Beibei Shui, a Chinese immigrant living in the state of Indiana, attempted to take her own life while she was 33 weeks pregnant. The father of the child had left her, she was despondent, and she was depressed. As a result of that suicide attempt, although she did not take her own life, the pregnancy was lost. Shui was arrested, charged with murder and feticide, and faced 45 years to life, 45 years in prison. The Guardian described this as an example of, quote, the creeping criminalization of pregnancy in America. And again, this is as a result of her seeking medical care in the context of her suicide attempt and depression, medical care being summoned for her. And instead of her being treated like a patient, her conduct during pregnancy was criminalized. and she faced significant time in prison. After international outcry, Shui was charged with misdemeanor criminal recklessness and released from prison in 2013 after serving approximately a year in jail, in prison. And then I want to talk about a more recent post-ops case from just this last year. A 19-year-old Nebraskan named Celeste Burgess and her mother, a 42-year-old woman named Jessica Burgess, were arrested and charged last year after the police obtained their private Facebook messages in which they were discussing obtaining mifepristone, the abortion medication drug. They were charged with violating Nebraska's abortion law because Celeste was over 30 weeks pregnant at the time that the abortion occurred. And this demonstrates, again, the power of policing, not only of medical records, medical relationships with professionals and pregnant people, but also the broader scope of law enforcement in electronic communications. This case came to the attention of law enforcement after neighbors observed that the young woman was pregnant 1 week and then not pregnant the next. So this also involves, for example, the commandeering of social networks, quite literally in terms of Facebook, but also in terms of community networks. So what does this mean? What kind of commonalities do we see over time? So one, back to the basic point, right? Police are central to the enforcement of abortion and of pregnancy-related crimes, even before Roe and Casey were overturned. That there is pervasive cooperation and commandeering of so-called caring spaces as a result of the cooperation with law enforcement and caring staff in places like hospitals, and other places where individuals might go for support. So that could be their friends or neighbors, it could be hospital staff, right? And this process of sort of enmeshment and collaboration between law enforcement and caring spaces like hospitals is what a legal scholar, Sunita Patel, calls transinstitutional policing in a wonderful forthcoming article in the Harvard Law Review. It also demonstrates the way that the state is targeting people who are pregnant and seeking to terminate pregnancies through the monitoring of their intimate communications or through routine investigations that involve their social networks. It also demonstrates the failure of things like the Fourth Amendment and HIPAA to protect pregnant people who seek either abortion or pregnancy care. I think it also demonstrates that we need to think about different approaches to how to protect reproductive autonomy in this context, right? Mainstream feminist movements and pro-choice activists have focused on things like challenging abortion protections, challenging abortion restrictions under state constitutional provisions. They've also looked to develop processes by which individuals can travel out of state or to other jurisdictions where abortions might be available, and to protect doctors who perform those abortion, as well as nonprofits that facilitate access to abortion, as well as the expansion of First Amendment rights. And I think those are all important, but I think it's also important for us to really fundamentally question the role of law enforcement in our society more generally, and in caring spaces more specifically. And as a result, I think that this means that we have to be thinking seriously about abolition, as well as reinvestment in community spaces where women and other people capable of pregnancy can receive the kind of care that they need in a timely fashion, to embrace notions of reproductive justice that suggest that people not only need to have the negative right to prevent the state from making interventions into their intimate spaces, but also positive rights to be able to access resources to make their choices more meaningful. And so I can talk a little bit more about abolition in this context, but I think it's important for us to recognize some of the limitations of the traditional focus on courts and legislatures, and really think about how we mobilize communities around creating safe spaces for people capable of pregnancies to make choices about how they want to live their lives and how they want to govern their own bodies. Thank you.
Our next presenter is Professor Bach, and she pre-recorded her presentation. So I guess our AV, wonderful
Good
AV team.
afternoon.
Okay.
First, I want to say thank you to Professor Kessler and to the students for inviting me, and to really sincerely apologize for not being able to be there today with you in person. If it was a really big commitment over here that stopped me from getting on the plane, so I really wish I could be there with you. It's a real pleasure to be here and talk to you about my book in the context of this exciting symposium you're doing. I want to begin today by locating myself in the work and telling you why I spent 6 years of my life working on this project. So I've spent about the last 25 years representing children and families in courts where poor people are heard: social welfare courts, housing, eviction, juvenile defense. And when I entered the academy, what I quickly started to write about was the relationship between the systems we set up purportedly to care for folks and the systems we use to punish them as they function in the poor communities where I've been representing people for so many years. So flash forward in about 2015, while I was running a conference at the University of Tennessee, I was approached by a group of activists to see if I could help them figure out what was happening with a law on the books at the time, the Tennessee Fetal Assault Law. This research started by answering that call, but I kept at it because it was an extraordinarily clear example of a phenomenon that I had been seeking to name and describe for many years. So I want to start just with the sort of basic case story in the book. On one level, this book is about 120 prosecutions of defendants in Tennessee for the crime of fetal assault. It's a crime that was in existence for about 2 years, between 2014 and 16, and it criminalized in utero opiate transmission, resulting in harm to the fetus. These defendants are 120 of nearly 2,000 documented prosecutions or forced interventions against individuals because of pregnancy-related conduct that took place and have been documented between 1973 and 2020. The data for the book consisted of 3 basic sources: the criminal court files, which I got through a variety of public information requests, hospital records of infants who were born with neonatal abstinence syndrome during the period, and a series of qualitative interviews of professionals working in the systems where the cases took place, and some medical professionals. As you can see from this slide, in which red represents more prosecutions and green indicates none, prosecutions took place predominantly in the northeastern Appalachian region of Tennessee, where Knoxville, Tennessee is, where I work. But there were also about 25 prosecutions in the southwestern corner of the state, in Shelby County, the home of Memphis, Tennessee. So in effect, what I was able to look at was how this crime played out in 2 very different geographic spaces. In the Northeast, we have predominantly rural, white Appalachian poverty. And in Memphis, we have a majority Black city and a far more urban space. The geography would turn out to matter. Those who supported the law said that the prosecutions would lead women to treatment. They said that through the discipline of the court system, these bad, read white mothers giving birth to these babies would be transformed. They would become good white mothers. If it worked, fantastic. And if it didn't, then they would get the punishment they deserved. In 2016, though, the law sunset. So after that point, this particular conduct was no longer a crime in Tennessee. One might ask then why one would want to read or frankly write a book about the prosecutions. The answer, as I said before, is that the Tennessee Fetal Assault Law is a devastatingly clear example of an idea at the heart of American poverty policy: the idea of criminalizing care. In short, as I argue in the book, for those we stigmatize, for those who are poor, often Black and brown, but also low income and white, our systems say that the only kind of care they deserve is care mixed with punishment. Before delving in, I want to take just a moment to talk about how I use the words in the title of the book. While prosecuting poverty is fairly clear, our systems of prosecution target, to an extraordinary degree, those in poverty. Criminalizing care is a bit more opaque. Criminalization, as I use it in its most basic form, happens when a society uses criminal law and criminal systems, criminal courts, police, probation, to address a social problem. So we use our criminal system to prosecute crimes, murder, rape, robbery, assault, and individuals are punished by that system. Defendants here were almost without exception low income. So this is a story of what happens specifically when we use criminal systems against those in poverty. But criminalization here refers to also three broader phenomena. When society makes conduct criminal when a social welfare solution might be available, for example, laws criminalizing homelessness. Criminalization when criminalization also occurs when applying for a social welfare benefit feels like being processed for a crime. Think finger imaging, home visits as a condition of welfare eligibility. And then finally, criminalization occurs when seeking help from a social welfare system, in this case, a healthcare system, puts individuals at risk for exposure to other more punitive systems, for example, family regulation or criminal systems. The word care I use in the book in its broadest and most ethically imbued sense, at a minimum we owe safety, security, health to the members of our society. Part of what drew me into this study and kept me there was the hypothesis about the relationship between care and courts and care and punishment. Here is just a smattering of the legislative history. So for example, Barry Stabbas, who is the district attorney in Sullivan County, the home of the most prosecutions for fetal assault, says, I think when we have this statute, and I've spoken to a couple of people, of agencies, and they're saying if we pass this, if we create the crime, he's saying, we're going to be able to bring lots of women into the program and lots of resources, and the judges, I think, will find the resources to do that. So by his understanding, the only way to address this healthcare problem, this social welfare problem of infants being born with neonatal abstinence system, was to create a crime. Senator Kelsey says, the other issue that this committee needs to consider is that these women are usually not going to be sent to jail at all, but the beginning of the prosecution is what will be able to send them to drug treatment. So in his formulation, prosecution is a road to care. And finally, and perhaps most disturbingly, Representative Finney, in talking about the high quality programs offered for the drug court, says we have a drug court. We have a great drug court in Jackson, Tennessee, and I'm sure it would benefit from something like this. So now, in his formulation, drug court is such a wonderful program that it should benefit, it should be available, so let's create a crime so people can take advantage of it. To understand just how strange this idea is conceptually, I think we should start with some legal basics. Our society has many, many institutions, all of which are structured through law. The purpose of some of these legal systems, think Medicare, Medicaid, public housing, food stamps, welfare, is to provide care and support. Other systems are set up to punish. The strange thing today, though, is that in poor communities, as I've already alluded to, all too often, these two sets of systems merge. My book explains, through a detailed exploration of the fetal assault law and the systems in which they took place, what happens as a result of this merger. In short, what I set out to do on some level is to take the supporters of the law at their word and attempt to figure out if the prosecutions were really about care in any meaningful sense of the word, and what that might teach us about the relationship between punishment and care in our social institutions today. So first to the data. So we coded the case files for a variety of factors, and one of the things we looked at was whether there was any indication at all in the criminal court file that treatment was thought about, suggested, or offered, or required in the course of the criminal case. And what we found was that although, as you will recall, those who supported the law said it was about providing treatment, when we looked at the actual case files, what became clear was that the rhetoric of treatment was mostly a smokescreen, hiding punishment. In the vast majority of cases, about over 70%, there was no indication in the criminal court files whatsoever that the women were offered treatment as part of the case. Instead, despite the promises of those who supported the law that jail played no role, women spent time in jail. both before pleading guilty for an average of 62 days in East Tennessee, and they served jail sentences of up to a year after pleading guilty. The cases were also emblematic of systemic problems in misdemeanor prosecutions. Despite significant evidence that many of the women were in fact not guilty of the crime, the vast majority pled guilty. There were no motions filed, no hearings held, and no trials held. So despite the fact that it was quite clear on the face of the pleadings and as a result of the information in the hospital records that we obtained, that many of these women were perhaps not guilty of the offense. In fact, 30% of the defendants who pled guilty did not give birth to an infant whose hospital records indicated that the infant had NIS, precisely the diagnosis that was purportedly targeted by the law. The pressure to plead is something we know a lot about from other scholarship, but it's striking in this case in the ways that the family regulation system and the criminal legal system work together to compel pleas. So if it wasn't about care, instead, as is in the case and the lower end of the criminal system, the prosecutions were all too often just about the money. Displayed on this slide is one cost sheet indicating that this woman owed the court almost $4,000 in costs and fees. Recall that I said at the beginning that the vast majority of defendants were poor, but their poverty did not decrease the imposition of significant criminal debt. So in the majority of cases, the rhetoric of care was nothing more than a smokescreen hiding punishment in the form of plea bargains, almost no procedural justice, jail time, and the imposition of substantial criminal debt. But what about care? In the minority of cases, the criminal court files did indicate that they were offered or required to participate in treatment as a part of their prosecutions. What's clear, though, is that in poor communities, care is increasingly only available inside or proximate to punishment systems, and that this particular form of care comes at a high cost, high risk, and all too often in a deeply corrupted form. To understand how this happens, you need to think about the criminalization of care along two paths. The first path is a path from healthcare or social welfare systems leading into punishment systems, in this case, family regulation and criminal legal systems. In the book, I trace the ways in which law enabled presumptively confidential information obtained or disclosed in the healthcare setting to travel from that setting into these more punitive settings where it served as the basis for child welfare cases and for prosecution. Just to give you some sense of this data, a careful review of the court files revealed that 80% contained information obtained or disclosed in a healthcare setting. As you'll see, this includes diagnostic and treatment information. This slide is just one of the criminal court complaints. The information here includes information obtained or disclosed in the healthcare setting, in this case, tests of the infant and the cord blood, and that forms the basis for her prosecution. But it's not, the path to criminalization of care is not just linear as it appeared in those cases, it's also intertwined in more complicated ways with our punishment systems. So just to give you a sense of this, in one of my qualitative interviews, I talked to a rural drug treatment coordinator in a court in a rural jurisdiction in East Tennessee. We asked her, she'd be identified to us as the person who could get treatment for folks in the form of detoxification, short-term detox beds. And we asked her how she did it, and this is what she said: lock them up, clean them up, start them over. She explained that if she could just get them on some little charge, then she could get them in bed. Similarly, is what you see before you, a quote from Dr. Stephen Lloyd. Dr. Stephen Lloyd is a tremendously important doctor in the addiction space in Tennessee. He currently chairs the commission giving out the opioid abatement dollars. And he said in our interview, even knowing what I know, if I needed somebody in treatment that didn't have insurance, I'd tell them to go to Greene County and get caught shoplifting. What he was basically saying is the best way to get treatment in Greene County is through the drug court. So why don't you go shoplift to get it? And finally, reflecting an even deeper intertwining of punishment and care are the devastating and complicated stories told by Carolyn Suffren in her book, Jail Care, in which she talks about the experiences of women seeking care in the jail where she was working. I argue in the book that the nature and quality of care is deeply compromised by the proximity to punishment. For example, in a phenomenon I call care at a cost in Shelby County, where all 25 women were able to access the services of the Shelby County Drug Court, defendants did access that treatment. But the price they paid in terms of time in court appearances, time in jail, both pretrial and upon failure, and folks failed at sort of standard rates at about 50%, and risk of severe punishment for that failure was quite high, care at a cost. Second, again, Dr. Lloyd talked about this phenomenon in our interview. Care gets corrupted inside these systems when people other than patients and doctors are making decisions about treatment. So referring to child welfare officials or family regulation officials, as well as courts, Dr. Lloyd says they're practicing medicine without a license. And finally, in the words of one of the defendants, who explained how she thought about the impact of fetal assault on her care, she said the laws in effect prevented it from being a care issue. It became a law and a liability issue. So what do we do? First, separate care systems from punishment systems by eliminating and narrowing the legal pathways that allow communication between those systems. Second, eliminate the on-the-ground reality for many that punishment is a road to care. And finally, significantly grow genuine dignity-enhancing care systems and shrink punishment systems. But before I want to sort of put a little meat on those bones, I want to acknowledge how deeply intertwined with intersectional forms of structural bias everything I've told you today is. The idea, as I hope the book sheds some light on, is deeply institutionalized in the rules, the practices, the procedures, and the structures on the ground. That's why it, quote unquote, made sense to create crime, to create care in Tennessee. And I also want to think, as I think about some solutions, about some of the lessons that abolitionist practice teaches us. That doctrine or that set of ideas asks us to distinguish between reforms that strengthen rather than weaken punishment systems. How do some reforms place more power and more resources into punishment systems? And what are reforms that actually shrink punishment and grow care? Or in the words of abolitionist praxis, what does it mean to divest on the one hand and invest on the other? So attempting to propose solutions along those lines, I think talk in the book about things like reforming healthcare privacy laws to narrow disclosures. I'm thinking a lot with some other scholars around Fourth Amendment remedies here. And then I also think when it comes to the criminal legal system about, whoopsie, sorry guys, about getting rid of mandatory report and other reforms that will block information flow. There's a variety of federal laws that are drawing cases in. We think about them as legal magnets, drawing these cases into the family regulation system. And then you have to also look at those porous boundaries between family regulation and criminal systems and think about reforms that will both shrink and separate those systems. But legal reforms are one thing and fundamental transformation is another. Ultimately, as Monica Simpson and the movement towards reproductive justice has long taught, the answers lie in placing on the government and society the obligation to create conditions under which women, families, and communities can exercise the human right to self-determination. So that's the book. Today, I'm working on a whole bunch of other things. I have the great privilege of working with Madeline Wasilchik at South Carolina, some folks at Texas, and the fantastic folks at Pregnancy Justice on a national study tracking pregnancy prosecutions post-Dobbs. So we will be working on that and communicating about that. And as I mentioned before, we're working on with some other folks on some Fourth Amendment issues and how to shut down the stream of information flow at the bedside of care. So it's a great pleasure talking to you. Again, I'm super sorry that I'm not there. Enjoy the conversation and the conference.
Okay, so now is the opportunity to hear questions from the audience. I just want to say that the presentations took a little longer, so if we could go till 1:05, that would be fantastic, so we can have a good discussion. I guess the first question, Al, that's been asked, it's a broad one. What is your opinion on the impacts of the role of systemic racism in the carceral system, and more specifically, its impacts on the criminalization of women of color? And I think actually, Professor Bach isn't here to answer the question, but I think Professor Ocen or Professor Mondé are highly qualified to answer the question given their research. So yes, that's the question.
I can start. So I often think about the experiences of women of color through the language of controlling images. This is framing that comes from Patricia Hill Collins. And what that means is that when systems encounter the criminal legal system, social services encounter Black women specifically, but controlling images certainly extends to other women of color, Latinx women, for example, there's already an assumption of guilt. There is already an assumption of criminality. And we see those tropes going way back into history, whether we think of those tropes in the form of the sapphire in particular, this angry Black, confrontational, combative woman. We think about the welfare queen, this trope that was very much, became very much embedded within the public psyche during welfare reform in the 1990s. And if we think about the war on drugs, certainly this image of the quote unquote crack fiend. And so when women are returning from carceral institutions, the assumption, and we saw this with the example I gave of Isabel, the assumption is that they are involved in a crime, whether or not you have evidence, whether or not it was the reading of the drug test was a mistake, they are viewed, right, by default as being criminal. I mean, in terms of just actual policy, when we think about legislative policy, the impact of laws on the criminalization of Black women and women of color, we can go further back, but we can certainly think about the war on drugs as a touchstone moment. We see the exploding rate of incarceration among people of color, women being a significant population that have increased in terms of their composition of the criminal justice system, in large part because of the criminalization of drug use. And many more eloquently than I have spoken about the really interesting dichotomy between the approach to thinking about addiction to crack cocaine during the 1980s, early 1990s, and the dichotomy between the approach to opioid addiction. Not that that approach has been without many faults, but there certainly was no public health language or framing when it came to thinking about addiction, when those who were addicted were primarily Black and brown. And we see that continuing into how we prosecute and criminalize women of color today.
So first, I just want to say this is really cool that, at least on my view, it looks like I'm on the dais with you all. So that's pretty awesome. Kudos to the tech team. So I think I agree wholeheartedly with what's been said. in terms of what I might contribute here, I would also just say that there are a number of pathways that Black women, girls, and femmes encounter that increase the likelihood that they will be subject to prosecution, criminalization, surveillance, and arrest for many of the reasons that Professor Bach talked about, in combination and intersecting with the notion of controlling images. So, Black girls, for example, are disproportionately targeted for suspension and expulsion simply because they are Black girls and the way that they express their gender identity. So the notion of gender nonconformity is an important aspect of this. So Black women, if you read the work of Saidiya Hartman or Sarah Haley or Wabiana Luamo, there are all kinds of ways in which Black women have been framed as non-women and non-men, right? So there are aspects, sort of a liminal gender category that Black women have been placed in that subjects them to discipline and punishment. So again, Black girls being viewed as aggressive, more masculine, and that attracting, on the one hand, less protection and more criminalization when they attempt to defend themselves when they're being sexually harassed, for example. Or Black mothers in the context of social welfare or family policing systems not being seen as nurturing, being seen as emotionally distant from their children, being seen as violent toward their children. The sort of echoes of this emanate from enslavement. The notion that Black women weren't maternal or nurturing was justified as a reason for natal alienation, for separating families from one another. And we continue to see this in the 1960s and 1970s with things like the Moynihan Report, or federal reports like the problem of crime in a free society. These same kind of tropes about Black women as failed parents, as failed mothers, in need of discipline, in need of surveillance, and in need of punishment in ways that didn't attend to their white counterparts. So I think that's another backdrop to the story about why and how it is that Black women, girls, and femmes are subject to heightened rates of criminalization, surveillance, and punishment in a variety of different systems, ranging from the welfare system to the education system to the health system to, of course, the formal criminal legal system. And I just apologize, I have to leave in about 5 minutes. So I just wanted to say that before we took the next question. Thank you.
Okay. So actually, since Professor Ocen needs to leave in a few minutes, I have a question which relates to her presentation, which is I feel like there's a bit of there's a tension or a discussion going on about whether law is the solution or the problem. And you talked about empowering communities and political mobilization and potential alliances between the reproductive rights or justice movement and broader abolitionist movements to abolish police or abolish the child welfare system as we know it. And I was wondering if you could speak to that, sort of your perspective on law in all of this.
Yeah, so I think law is necessary but not sufficient, right? So we can't cede territory in the space of courts or legislatures. We need to continue to press and fight against abortion restrictions and other restrictions on reproductive choice, wherever they may be. So that speaks to litigating not just with respect to abortion, but also litigating with respect to the reproductive interests of women in jails, people in women's jails and prisons and detention centers, right? Where for example, people in migrant detention centers in Texas and elsewhere were being subject to forced sterilization or did not have access to things like abortion, right? Those are also important claims that we need to be thinking about to expand the space where we understand the restrictions on reproductive autonomy, to not just in, sort of free world hospitals, which is a term that Ji-Soon Song is developing in a upcoming paper called Patient or Prisoner, which I would commend to you all in her work on ERs as carceral settings as well, right, where she talks about this kind of encroachment and commandeering by law enforcement into these spaces. And I think by broadening the scope of the spaces that we understand, one, to be carceral, and the institutions that we understand to have implications with respect to reproductive autonomy, it broadens the movements. It also broadens our understanding of how these systems are operating so that we don't leave people behind, right? Roe was the law of the land when Crystal Ferguson was prosecuted for using drugs in South Carolina in Ferguson versus City of Charleston. You know, Roe was the law of the land when Black women in South Carolina were being prosecuted for murder, right? At the time when they had experienced pregnancy losses that may have been due to no fault of their own, or they may have been caused by using drugs, right? But nevertheless, these women were criminalized rather than being provided support. So expanding the scope allows us to really address all of the different permutations of reproductive violence against women at all points of race, class, gender, sexual orientation. I think it also allows us to rethink and reimagine what reproductive justice looks like. So it's not simply access to abortion and contraception. It's access to care, non-carceral care. It's having support for childcare. It's having support for wages and housing. So it allows us to really expand the scope of the kinds of remedies that we pursue, which may not be available through courts, but only through mobilization, movement, and mutual aid. And I think that allows us to have more sustained victories as well, because as we know, once we litigate cases and there's a remedy imposed by a court, often it's taken out of the hands of the very community members that are most impacted by the state violence that led us to courts in the first place. So I think that there's a lot of ways that an abolitionist framework can help inform and invigorate movements toward securing reproductive rights and reproductive justice for vulnerable and minoritized communities across the country.
Thank you. So I'd love for you to stay as long as you can, but we're going to keep going. And so thank you so much for presenting and being here today. We feel so grateful that you were able to be participate in our conference. So thank you so much.
Wonderful. Thank you.
Okay, so I have a question for Professor Mondé. If you could design a support program for women leaving carceral settings, what would that program look like?
I speak more about this in the conclusion of my book, including speaking about abolition of dehumanizing policies within the context of prisons, which was a little bit beyond the scope of my my talk today. I think it is essential for formerly incarcerated people to be engaged and a part in leading the process of developing the very institutions that they are referred to, because even when well-meaning people are invested initially in developing these post-prison and jail rehabilitation or transitional systems, they don't have the perspective. They don't have the perspective not just of what it means to be a person who's been incarcerated, but have the trauma of all that that means. So when a person enters a women's prison, that is not the first time that they've encountered carceral institutions, right? Women and girls and people who identify as women and girls, when they are children, they are often victimized at higher rates than the wider population, and all of that trauma, they carry with them. And so having individuals who have and can identify with those experiences is really, in my opinion, essential, because they can give voice to those experiences in a way that's not coming from, and I'm an academic, but it's not coming from literature, is not coming from this disconnected knowledge of those experiences, but it's coming from having traversed those experiences themselves. And yeah, that would be for me, first and foremost. They need to be leading these organizations, and they need to be listened to. And unfortunately, oftentimes they are not by state agencies.
Yeah, thank you for that question. I have another question about agency, because I felt like a really strong theme in your book that maybe hasn't come out enough in the discussion today is, like you said in the beginning of your talk, that women enmeshed in these systems, or people enmeshed in these systems, don't just passively participate. They're not just passive victims. I'd love to hear more about your research in terms of that, how they navigate the system and maintain their identity as human beings and their dignity.
All right. So the framework that I use throughout the book is duality at the margins, and that draws from the sociologist W.B. Du Bois' framework of double consciousness. So on one hand, women are or will acquiesce to institutional requirements to abide by rules and regulations. And this is not because they aren't willing to challenge those expectations, but because they know that those rules and regulations are often the barrier between them and their children. That being said, they are often engaged in acts of resistance. Sometimes those acts of resistance are subtle, but they are acts of resistance nonetheless, especially because of their marginalized position. So them willing to critique these organizations, and they, a little bit of that came through with one of the conversations that I referenced. They will critique these organizations. They will call out their flaws. They don't want to be penalized because, again, they're thinking first and foremost, oftentimes, about reunification with their children. They will think about how they define morality. So we often see the language of good mothers and bad mothers in literature by practitioners, by institutional leaders. They are much more nuanced in their understanding of what that means. Good mothers can make bad decisions, right? They do not see someone as the totality of an experience or an act. They see those as key moments. And so they resist the narratives that are placed upon them over and over again in different ways. They resist the expectation that mothering looks like only one thing. I speak about the fact that when agencies and organizations and even transitional spaces speak about mothering, the assumption is that it comes from a very cis, white understanding of what motherhood looks like. And these women engage in mothering practices that are born out of their marginalized spaces that may look different, that may rely on communal efforts, right? Relying on peers and friends and mothers and aunts who can also fill in those gaps when they don't have the economic resources or when they're separated from their children. And so thinking about resistance in this way, I think for me was illuminating because it demonstrated that they, despite their very limited resources, resisted the narratives about them over and over again.
Thank you. Okay, well, I guess we're using Slido, but we do have an audience here. And so I thought I'd take the opportunity, and as well as some experts from other departments in the university who are working in fields and in practices that are implicated by the themes of this panel. So I just wanted to open it up to the audience and ask if anybody wants to ask a question, not on Slido. No questions? Yes, okay. Thank you. I can repeat it because we don't have a microphone there, so.
While listening to the educated, intelligent women speak, it's come across my mind, and maybe other women, it's come across their mind before, is if women have become the new whipping boy for the rich white men to keep down. And reproductive health is the way to do it. Mm-hmm. And the way the Christians, and then they use religion as an excuse, and the way that was the way Christians were able to endorse slavery or the genocide of the First Nation was that they were subhumans. And women are subhumans because we have periods, we're weaker, we get pregnant. It's disgusting. It's like the men don't get pregnant. So if you could just say, and policymakers and police enforcers are mainly white. So
So I think the question that you're asking, what is the role in patriarchy or sexism in this system, right? That women are being are subhuman, right? With this attack on reproductive rights and justice. So bringing. Well, I mean, I would certainly say that I believe that what's happening is an attack on women and people who can become pregnant, and it's as the prior panel said, it's about our freedom, right? It's a total attack, and there are ripple effects that are massive are all through the law, right? So I think there's been so much research and activism to completely agree with that, but I don't know if you want to add anything to that.
I mean, when we think about interlocking systems of oppression, oftentimes we think about race, class, and gender, and sexuality, but it extends beyond that, right? And so context, depending on the context, what those interlocking intersections of oppression mean, will transform depending on who is in power and who is the target of being disempowered. I focus on women who are in carceral institutions. So I'm thinking about one's freedom status as a space in which oppression is rendered, and a space in which individuals are pushing back against oppression. But that's going to evolve, right? The language of oppression changes from space to space and context to context. And oftentimes one can be caught, if one is not prescient, can be caught off guard, not recognizing why is this now the new, and it's never really new, it's just reinvented or the language just changes, a new source of oppression, when the reality is it really just evolves depending on, so it can be immigration status, right? You spoke about the invention of race, right? You have to dehumanize someone to justify their oppression. And that could align with race, it can align with ethnicity, and of course it can align with gender identification. I certainly think that what we're seeing now, not to be a pessimist, but will evolve into something else in 15, 20 years. And that will be done to oppress a particular group of individuals to meet or justify the oppression of that particular group. And there will be another group targeted depending on the power that's being sought and the particular ideological or political gains that are at play, they're at risk, they're being fought over.
Okay, are there any other audience questions? Okay, well, let me thank our panelists today for this really interesting conversation. A little depressing, but hopefully we can speak during the lunch time about about what we've heard and think about solutions as well. Thank you.